Welcome to Eternal Diary. I was reviewing this particular script last Tuesday, and I stopped partway through to write down the one move that makes everything else possible. It happens quietly at a desk, 11 days before Vesper signs anything. One filing. One specific form. The company she worked for spent $200 million finding out what that form was actually worth. This is Eternal Diary. The call came on a Thursday morning in late October. I was sitting at my desk on the 14th floor of the Aldercroft building, looking out at a harbor I still hadn't gotten used to, when my phone lit up with a number I hadn't saved but recognized immediately. The country code was wrong. It was being forwarded through the old Hargrove corporate exchange. Someone calling from a company that was, by that point, technically in receivership. I let it ring. Not because I was being cruel, because I wanted to hold the silence for one more moment before everything became very loud again. It rang out. Then again. On the third attempt, I picked up. Vesper? The voice belonged to Gideon, who was the closest thing I'd had to a friend during my 6 years at Hargrove Technologies. He sounded tired in a way that had nothing to do with the hour. Are you seeing the news feeds? I'm not looking at them, I said. Hargrove filed Chapter 7 this morning. Not reorganization, liquidation. I know, I said. There was a pause. Of course you do. Another pause. The board is saying it was mismanagement, but the institutional investors know what blocked the European rollout. They know what blocked Japan. I didn't say anything. Was it always the plan? Gideon asked. All of it? I thought about that honestly. Not all of it, I said. The plan was just to survive. The rest followed from that. He was quiet for a moment. Outside my window, a container ship moved slowly through the harbor, low in the water, loaded past the draft marks. Well, he said finally, you survived. I set the phone down after we said goodbye and sat with the harbor for a while longer. The ship made no sound I could hear. It just moved, steady and heavy, through water that didn't care what it was carrying. I had been 27 years old when I joined Hargrove Technologies. That felt, sitting in my office at 34, like a different person's life. But it wasn't. It was mine. And if I was going to understand how a company with 800 employees and $200 million in venture backing ended up in federal bankruptcy court because of one piece of paper I filed on a Tuesday afternoon 6 years ago, I had to start at the beginning. So, the beginning. I grew up in a household that treated knowledge like currency. My mother was an electrical engineer. My father was a patent attorney. By the time I was 12, I understood the difference between a method claim and an apparatus claim. By the time I was 22 and finishing my doctorate in biomedical engineering, I had already filed 2 provisional applications in my own name. Neither of them were commercially significant, but that wasn't the point. The point was that I knew how the system worked. I knew that the moment you reduce an invention to practice, the clock starts. I knew that a provisional application buys you 12 months to file a full non-provisional. I knew that the Patent Cooperation Treaty, the PCT, was the mechanism through which a single filing could establish priority in over 150 countries simultaneously, with a 30-month window to enter national phases in any or all of them. I knew these things the way some people know the rules of a game they grew up playing. I also knew what happened when you forgot you were playing. Hargrove Technologies was not glamorous when I joined it. It occupied 3 floors of a converted building and had the particular smell of all underfunded tech companies. Coffee grounds, cable insulation, and a vague anxious energy that came from people who knew the runway was shorter than the pitch deck suggested. I was hired to lead their neural interface division, which at that point consisted of me, one hardware engineer named Gideon who could make a circuit board behave in ways the laws of physics seemed reluctant to permit, and a part-time consultant who left 4 months after I arrived. The technology I was brought in to develop was, in theory, already half-built. In practice, the previous team had assembled a collection of components that worked individually and catastrophically together. The signal processing pipeline, the part that took raw electrical data from the neural recording array and compressed it for wireless transmission, was the bottleneck. Every existing solution sacrificed either temporal resolution or transmission bandwidth. You could get fast, or you could get complete. You couldn't get both. I spent the first 14 months convinced the problem was fundamentally unsolvable within the hardware constraints. I was wrong. But being wrong in that specific way turned out to be useful, because it forced me to look at the problem from a direction no one had tried. The solution came at 2 a.m. on a Wednesday in March, 3 years after I joined the company. I was sitting at my kitchen table with a cup of tea that had gone cold, staring at a whiteboard covered in equations that had stopped making sense 6 hours earlier. And then, in the way that insights occasionally arrive, not like a light switching on, but like realizing a light has been on for some time and you just hadn't turned to face it, I understood what the compression architecture needed to look like. It was an entropy-based method, variable, adaptive, dependent on the statistical properties of the specific neural oscillatory patterns being recorded. Not a static compression algorithm, but a dynamic one that learned from the signal in real time and rebuilt its compression model on a rolling basis. It was, technically speaking, a method, a process, a specific sequence of computational steps that, taken together, solved a problem that had been blocking the entire field of wireless neural interfaces for close to a decade. I wrote it down. I drew it out. I sat there until the sun came up. Then I took photographs of my whiteboard, because I had taken photographs of my whiteboards every time I made meaningful progress for the past 6 years. The photographs had timestamps. I had done this since graduate school. Not because I was planning a patent dispute, but because an engineer's documentation habits are like a surgeon's sterile field. You maintain them because the one time you don't is the one time it matters. I called Gideon at 6 a.m. "I need you in the lab in an hour," I said. "Is it done?" he asked. "I think it might be done." It was done. 3 weeks of prototyping confirmed it. The method worked. The temporal resolution was within 5% of a hardwired system. The wireless transmission was clean. The power draw was half of what the previous best solution required. Gideon ran the numbers 4 times because he didn't trust them the first 3. "This changes the product," he said on the 4th run. "This changes the field," I said. He looked at me in the careful way he had, the way he looked at circuit boards when he wasn't sure what they were about to do. "You're going to file this yourself," he said. It wasn't a question. "Yes," I said. "Before you tell anyone here." "Yes," I said again. He nodded slowly. "Good." I should explain something about the way I thought about intellectual property at that point in my life. I was not secretive or paranoid by nature. I was precise. There is a difference. Precision about ownership is not the same as distrust. But precision about ownership when you are a woman working in a field where ideas have a way of migrating toward the people with the most institutional authority, that is also survival. Hargrove's standard employment agreement included an invention assignment clause. Every employee signed one. The clause stated that any invention made in the course of employment or using company resources became the property of the company. This was standard industry language. This was also, in practice, where the complications lived. The method I had developed used, at various points, company equipment, company time, and company data. It also used my doctoral research from before I joined Hargrove, my personal theoretical framework developed over a decade, and an insight that had arrived at my kitchen table using my own electricity and my own cold tea. The legal concept relevant here is pre-existing IP and background IP. An invention assignment clause covers what you make during employment. It does not automatically cover what you bring with you. The line between the two is often unclear, often contested, and almost always defined by whoever has better lawyers. I was the daughter of a patent attorney. I had better lawyers than Hargrove thought. Before I told anyone at the company about the method, I called my father. He had been retired for 3 years by then, but he still had the sharpness that came from 40 years of watching inventors lose things they had built. We talked for 2 hours. At the end of the call, he gave me a name, Josephine, a former colleague of his who ran a boutique IP firm specializing in exactly this kind of dispute, the murky middle ground between employee invention and independent development. I met Josephine the following week. She was in her late 60s, small, with the particular stillness of someone who had made a career of reading people in rooms where reading people was expensive. She had a pot of very good coffee, and she poured it without asking whether I wanted any, which I respected. I explained the situation, the invention, the employment agreement, the timeline of development. She listened without interrupting, which told me something. "Walk me through the kitchen table part again," she said when I was done. I did. "And you can document that timeline? Show that the core insight came outside company premises, outside company hours?" "My whiteboard from that night is still in my apartment," I said. "I have the photographs."
"Time-stamped. I've done it for years."
One side of her mouth moved slightly. "You took photographs of a whiteboard at 2 in the morning?" "I take photographs of my whiteboards whenever I make progress," I said. "They're time-stamped. I've done it since graduate school." She set down her coffee cup. "Vesper," she said, "I think we have something to work with." What we had to work with was this. The invention was genuinely mixed. Some components clearly made using company resources, some components clearly predating employment. This was not unusual. What was unusual was the quality of my documentation. I had, without specifically planning for this moment, spent my entire career creating a time-stamped record of my intellectual development. Lab notebooks, photograph archives, emails to myself with attached sketches, a personal research journal I had kept since graduate school. The documentation didn't prove the invention was purely mine, but it gave me enough to make a territorial claim. Enough to say, this piece, and this piece, and this piece came before you. Those pieces are not yours to assign. Josephine filed a provisional patent application in my personal name. It covered the core method, the entropy-based variable compression architecture, with a set of claims drafted deliberately broadly. Broad enough to be defensible, specific enough to be enforceable. The provisional established a priority date. I then told the company about the invention. Looking back, I understand that this sequence, file first, disclose second, was the correct order. At the time, it felt like the only rational order. To do anything else would have been like leaving a window open in a storm and being surprised when things got wet. The response from Hargrove's management was, initially, exactly what I expected. Excitement. Congratulations. The word breakthrough used several times by people who didn't fully understand what they were congratulating me for. The CEO called me into his office and shook my hand in the way of men who believe handshaking communicates something meaningful about the future. Dorian himself was different. I should talk about Dorian because he is unavoidable in this story, and because the shape of what he really was, as opposed to what I understood him to be, took me longer to see than I like to admit. Dorian Hargrove was 33 when I met him. He had an MBA from a school that opened many doors, and a surface intelligence that was effective enough to be mistaken, in short meetings, for the deeper kind. He was VP of Strategic Development, which meant he sat in rooms where decisions were made and shaped the decisions toward outcomes that benefited him. He was handsome in an angular, slightly too deliberate way, the way of men who have been told often enough that they are handsome, that they have incorporated it into their posture. We had worked in proximity for 3 years before the invention. I had thought of him as a colleague, competent at the commercial side, occasionally useful when it came to resourcing, mostly irrelevant to the technical work. I had not thought about him romantically. Not because he wasn't attractive, but because I had learned early that romantic involvement with a superior was a door through which something always got lost. Usually the thing that got lost belonged to the woman. After the invention, Dorian paid closer attention. He started appearing in my lab in ways he hadn't before. Not disruptively, he was too careful for disruption. He asked questions. Good questions, actually. He was intelligent enough to understand the commercial implications of what I had built, and he was genuinely curious about the technology in a way that I, who had been mostly ignored for 3 years, found unexpectedly warming. I was aware, in a technical sense, that this warmth was worth examining. I examined it, and then I put the examination in a drawer because I was also 30 years old, and I had been working 70-hour weeks for 3 years. And when someone paid attention to you in a way that felt like seeing rather than using, it was difficult not to lean into it. We had dinner, then several dinners. By the time the full, non-provisional patent application was in prosecution, we were together in whatever the contemporary definition of that word is. I was careful. I told myself I was careful. I kept my professional and personal documentation organized and separate. I kept Josephine involved. I did not discuss the specifics of the patent strategy with Dorian, In the same way, I would not leave a finished report on a public server, not because I thought he would use it against me, but because precision about boundaries was a habit I could not afford to abandon. This was the right instinct. The problem was that I didn't maintain it everywhere. The problem was the conference. 8 months after the invention became known internally, Hargrove entered into preliminary licensing discussions with 3 major medtech companies. The technology was attracting serious attention, the kind that required Hargrove to begin presenting the invention publicly, building the IP profile that would make the licensing negotiations viable. Dorian handled the conference strategy. This was officially his domain. I was the inventor. He was the one who decided where to present, how to position, what narrative to build around the technology. He presented at the Westmere Neural Engineering Symposium without me. I found out 2 days before it happened. He had been accepted to present 3 months earlier and had not mentioned it to me. The abstract, which I saw for the first time when Gideon forwarded me the conference program, listed the invention under the company name with Dorian as the presenting author, and credited the Hargrove R&D team in a way that obscured the existence of any individual inventor. I called him immediately.
"It's a commercial presentation," he said. His voice was the voice he used in meetings, measured, slightly deliberate, as if he was translating his thoughts from a more precise internal language. "Not a technical one. The patent is filed. This is about positioning the product."
"It's my invention," I said.
"It's a company asset," he said. "The filing is under the company."
"It's filed in my name," I said.
"Josephine filed it in my name."
There was a pause, brief and specific.
"I thought that was resolved," he said.
"It was never a question," I said. I went to the conference. I presented my own session, a technical one, in the afternoon, where the audience consisted largely of other engineers, rather than the venture people and pharma executives who had filled the morning session where Dorian spoke. My presentation was more detailed, more precise. The people in the room understood what they were looking at. Several of them found me afterward and said things that engineers say when they have seen something that genuinely changes the calculus of their field. Dorian's morning presentation had been about market opportunity. Mine was about the actual invention. The difference between them was the difference between an advertisement and a manual. But the people with money had been in the morning session. This was when I should have understood more clearly what was happening. I had the information. The individual data points were all present. But I was in a relationship with Dorian. And when you are in a relationship with someone, you apply a different interpretive framework to their actions than you would apply to a stranger's. You look for the most charitable reading. You find it, you move on. I moved on. The licensing negotiations with the 3 medtech companies progressed over the following 18 months. I was involved technically. Dorian handled the commercial side. The company retained outside patent counsel, not Josephine, who remained my personal attorney, to manage the prosecution and licensing of the patent portfolio. During this period, 2 things happened that I tracked carefully but did not fully interpret in time. The first was a change in the company's IP management structure. Hargrove hired a new general counsel, Arabella, who had previously worked at a large firm doing patent licensing for pharmaceutical companies. She was technically sharp, aggressively commercial, and she had a particular way of looking at me in meetings that I recognized eventually as the look of someone who had done an assessment and come to a conclusion she wasn't sharing. Arabella and Dorian had known each other professionally before she joined the company. I learned this later. At the time, I knew only that she was competent, that she sat close to power, and that she seemed constitutionally incapable of acknowledging that the difference between a company asset and an inventor's personal IP was anything other than a negotiating position. The second thing that happened was the licensing deals. 2 of the 3 medtech companies signed. Not small deals. The combined licensing revenue was projected at $38 million over the first 5 years. Hargrove's board was ecstatic. The valuation shifted significantly upward. Series C investors appeared. My name appeared in no press releases. Dorian's name appeared in several. I raised this in a meeting. I was told that IP ownership was clarified internally, and that attribution in commercial contexts follows company policy. I asked what policy specifically. I was referred to Arabella. Arabella gave me a document. It was 8 pages long and said, in language carefully arranged to be difficult to argue with, that all inventions made by employees using company resources were company property, and that any claims to the contrary would need to be resolved through arbitration.
My provisional application was filed before any of this was in dispute, I said. The company's position is that the provisional application was made using company resources and company data, Arabella said, and is therefore subject to the assignment clause in your employment agreement. Josephine's position is different, I said. Josephine represents you personally, Arabella said. The company has its own counsel. I left that meeting understanding, with a clarity that was not comfortable, that the company had made a decision about what the invention was worth to them and what I was worth to them, and that these were 2 very different numbers. I called Josephine that evening. Tell me the status of the PCT, I said. You haven't filed it yet, she said. The PCT application? I had discussed it with Josephine 8 months earlier, when the licensing discussions began to look serious. The domestic non-provisional was in prosecution. The PCT, the international filing, was something we had discussed, but I had not yet authorized. It was expensive. It required decisions about which countries to designate, which claims to prioritize. I had been, in retrospect, slow about it. I need to file it, I said. Yes, Josephine said. You do. Can we do it before the provisional expires? The provisional expires in 6 weeks. We can file the PCT within that window. But Vesper, the company is going to notice. Once the PCT is in the international search database, it's visible. I know, I said. And they're going to argue that the PCT filing is also covered by the assignment clause. What do you think? I said. Josephine was quiet for a moment. I think the assignment clause they have is boilerplate. I think the claims in your PCT application, properly drafted, can be positioned to cover the improvements and extensions of the method that were developed in parallel with your personal research, not exclusively using company resources. And I think the burden of proof in a dispute over inventorship and assignment in federal court sits heavily on whoever has the better documentation. And I have the better documentation, I said. You've always had the better documentation, she said. We filed the PCT application 11 days later. I filed it through a holding company that Josephine helped me establish. A personal IP holding entity I will call, for purposes of this story, Crestline Research. The PCT application named me as sole inventor. The applicant was Crestline Research. The filing covered 106 countries, including every major medtech market in the world. Germany, France, Japan, South Korea, China, Australia, Canada, the United Kingdom, Switzerland, and the Netherlands. The filing fee was substantial. I paid it from personal savings, money I had set aside over 3 years in exactly the way you set aside money when you are not sure what you will need it for, but you are sure you will need something. The PCT established an international filing date. That date was 3 weeks before the meeting with Arabella. I did not tell Dorian I had filed it. Let me explain how the PCT works, because the mechanism matters. When you file a PCT application, you are not immediately granting yourself patent rights in each of those 106 countries. What you are doing is establishing a priority date, a timestamp that says, as of this moment, this invention, in this form, belongs to this applicant. You have 30 months from that priority date to choose which countries to pursue formal patent protection in. During those 30 months, the invention's international filing date is established and cannot be displaced by a later filing. This meant that whatever happened with the domestic dispute, whatever Hargrove's lawyers argued about the assignment clause, whatever Arabella's position paper said about company resources and IP ownership, the international filing date was fixed. Immovable. Any company attempting to commercialize this technology in Germany, Japan, South Korea, China, or any of the other 103 designated countries would eventually encounter a patent application owned by Crestline Research, with a priority date that predated any assignment Hargrove could produce. The machine was set. Now I had to let it run. The next 6 months were, professionally, among the hardest of my life. The pressure to sign began quietly. A conversation with Arabella about IP housekeeping,
A memo from legal asking me to confirm the assignment of all patent applications arising from my employment. I responded to each one through Josephine, who drafted letters that acknowledged the communications without conceding anything. Then the conversations became less quiet. Dorian came to my apartment on a Tuesday evening. We had been together nearly 2 years by then. He sat on the couch in the way of someone who has rehearsed the sitting, and he told me that the board was concerned, that the licensing deals required clean title, and that my refusal to confirm the assignment was creating problems for the company. "The company is going to protect itself," he said. "Whatever that means." "Whatever that means," I repeated. "Vesper, this isn't personal." I looked at him for a long time. Not with anger, with the particular quality of attention you give something when you are deciding how to remember it. "When did you know?" I asked. "About the plan. When did you know they were going to take this position about the IP?" He didn't answer immediately, which was, in its own way, an answer. "They've always had a position on company IP," he said finally. "This is standard." "You've been building toward this for months," I said. "The conference, the press releases, the framing of the licensing deals. You were building a record that made it look like the company had always owned this." "You're describing standard corporate IP management," he said. "I'm describing what you did," I said. He left an hour later. We did not officially end things that night. There was a further month of diminishing contact, increasingly distant phone calls, the particular fading of something that has already decided to stop. But the conversation on the couch was when I understood what the relationship had been, in addition to whatever else it had also been. He had loved me, I think, or something adjacent to love, something that felt like love from the inside, while also being, from the outside, a strategic positioning. This was, in the end, the thing I grieved most. Not the patent, not the money, the question of whether anything had been real. I grieved it quietly, and I put it somewhere in the back of my mind, and I went back to the problem in front of me. The formal demand came on a Thursday afternoon. Hargrove's outside counsel sent a letter through Josephine, asserting that the non-provisional patent application and any derivative applications, including international filings, were company property under the assignment clause of my employment agreement. They demanded I execute an IP assignment agreement within 30 days. If I did not execute the assignment, the letter said, the company would file suit in federal court seeking a declaration of ownership, injunctive relief, and damages for any revenue earned by Crestline Research from the unauthorized assertion of the disputed IP. Josephine called me as soon as she had read it. "They found the PCT," she said. I assumed they would. "They're treating it as a derivative application covered by the assignment clause." Their argument being that the PCT claims are materially identical to the domestic application, which they argue is unambiguously company IP. Therefore, the PCT is also company IP, filed without authorization and should be reassigned. What do we have to respond with? We have the priority date on the PCT. We have the documentation establishing that portions of the method were developed prior to or independently of company resources. We have the fact that the assignment agreement they're relying on has language that is, at minimum, ambiguous about the scope of derivative international applications. Josephine paused. What we don't have, Vesper, is the resources for a prolonged federal litigation. I know, I said. Hargrove has $200 million in Series C. They can litigate this for 3 years. We're looking at $500,000 in legal fees minimum on our side. I understand the arithmetic, I said. Josephine was quiet. What do you want to do? And here is where I have to be honest about something. I considered fighting. The way you consider a door that you know opens onto a drop. You consider it, you map the distance to the ground, and then you choose. I had enough documentation to make the litigation painful for Hargrove. Possibly enough to win. But possibly is not certainly. And the 3 years and the $500,000 were real. And I was 31 years old with no other income, because Hargrove had quietly restructured my employment during the dispute period to put me on a technical advisory role that paid 60% of my previous salary. This last part was not subtle. It was meant to be not subtle. It was pressure, the kind that is invisible from the outside and crushing from the inside. I did not have $500,000. I had a PCT filing, a set of documentation that would cost enormous amounts to litigate, and parents who had raised me with the understanding that sometimes you hand someone the rope before they know what it's tied to. I called Josephine back 2 days later. "I'm going to sign the assignment," I said. The silence on her end was not surprise. It was the silence of someone confirming a plan. "Read me the scope language again," I said. She read it. The assignment agreement covered the invention as disclosed in U.S. Patent Application Number X, all continuation, continuation in part, and divisional applications claiming priority therefrom filed in the United States, and all rights to said invention within the United States and its territories. I listened to every word. "It doesn't mention the PCT by application number," I said. "It doesn't." "It says United States and its territories." "It does." "Does the phrase derivative applications appear anywhere in the document?" "No," Josephine said. "It doesn't." The document had been drafted by Hargrove's outside counsel, who were very good at patent licensing and not particularly experienced in cross-border IP disputes. They had modeled the assignment language on standard domestic IP assignment agreements. They had not ensured, or had not thought to ensure, that the assignment explicitly captured international rights. This was not an accident on my part. For the 3 months during which the assignment agreement had been negotiated through Josephine, I had watched the language carefully. Every time her responses raised the issue of the scope of the assignment, Hargrove's counsel had responded with versions that were incrementally clearer about domestic scope and consistently vague about international scope. I had not corrected this. A correction would have been volunteering information that clarified a scope I did not want clarified. It would have been telling them what they had forgotten to take. Josephine and I had discussed this approach. She called it passive claim preservation. She told me it existed in a gray area. Not fraud, not misrepresentation, but a studied silence about a gap in the other side's drafting that they could have found themselves if they had looked carefully enough. The gap was the PCT. The assignment I signed covered the domestic patent application. It covered all U.S. rights. It covered continuations and divisionals filed in the United States. It did not cover Crestline Research's PCT application, filed 11 days before the demand letter, designating 106 countries, owned by a holding company that Hargrove's assignment had not named, and whose existence Hargrove's counsel had apparently not fully investigated. I signed the domestic assignment on a Wednesday afternoon. I sent it back through Josephine. I did not go into the Hargrove offices after that. I tendered my resignation by email the following morning, citing irreconcilable professional differences, which was the sanitized version of the truth. Arabella replied to the resignation email. The reply was 3 sentences long. The first sentence confirmed receipt. The second said the company wished me well. The third reminded me of my confidentiality obligations. Dorian did not reply. I had 18 months of savings, a PCT application with a priority date designated in every major medtech market in the world, 30 months to choose national phase entries, Josephine, and Gideon, who had given his own notice at Hargrove 2 weeks earlier, having concluded with the logical precision he brought to circuit boards that the company he was working for was not the company he had thought it was. I moved cities. Not dramatically. I moved to a city on the coast where a cluster of medtech and neural interface companies had been building for the previous decade, the kind of place where the work I did was understood before I finished explaining it. I found a small office in the Aldercroft building, and I began the methodical process of building something new. The first months in that office were quiet in the way that only very focused work is quiet. I was not lonely. I was too busy to be lonely. There is a specific texture to starting over that has nothing to do with emptiness. It is, if anything, too full. Every decision is new. Every system has to be built. The coffee machine, the filing structure, the working hours, the way you answer your own phone. I rebuilt all of it. Gideon joined me within 3 months. He brought with him a level of hardware expertise that I needed, and also a quality of company that I had not known, until I didn't have it anymore, how much I had relied on. His first act upon arriving was to provide detailed and unsolicited opinions about the office coffee machine, which he considered inadequate. I replaced it, and I was right to replace it, and neither of us mentioned it after that. I also brought in a third person, Leandro, a patent litigation attorney Josephine had worked with on international IP cases for 20 years. He was Brazilian, had practiced in 4 jurisdictions, and had a specific expertise in PCT national phase prosecution that I needed more than I needed almost anything else at that point. We incorporated Crestline research properly. We capitalized it with a combination of my savings, a small friends and family round, and a convertible note from a medtech-focused angel investor who had seen my afternoon presentation at the Westmere Symposium 3 years earlier, and filed it in the category of things to revisit. The work in those first 2 years was the most technically demanding I had ever done, not because the underlying invention was complex. By that point, I knew the compression method the way you know the layout of a house you grew up in, by feel, without needing to look. But because building a company is a different problem from building an invention. An invention requires deep, singular focus. A company requires you to hold multiple kinds of problems simultaneously without letting any of them slip. We were developing a second-generation version of the neural compression method, an improvement that went beyond the original claims in ways that the PCT application had been drafted to capture. We were filing national phase entries in Germany, Japan, South Korea, and China, each one requiring its own prosecution strategy, its own relationship with local patent counsel, its own translation of claims into the specific requirements of each jurisdiction's patent office. We were beginning early conversations with research hospitals about clinical applications. We were also watching Hargrove. Hargrove, during this period, was doing what companies do when they have acquired a major asset they don't fully understand. They were licensing it. The domestic patent, now cleanly owned under the assignment I had signed, was the centerpiece of their IP portfolio. They had retained the 2 existing licensing deals and were expanding into new ones. Dorian had been promoted to Chief Strategy Officer. Arabella had become Chief Legal Officer. The company's valuation was high and getting higher. The narrative in the trade press was about a breakthrough technology and a company positioned to dominate a new market. My name did not appear in the narrative. Dorian's appeared frequently. The impression that emerged from the coverage was of a company that had invented something, not a company that had acquired something from the person who built it. I read the coverage carefully, and with the attentiveness of someone who is building a different kind of file. Year 3 was when Hargrove began moving seriously into international markets. They signed a partnership with a major German medtech conglomerate, a deal worth, by the trade press estimates, upward of 70 million euros. The partnership involved manufacturing, distribution, and licensing of the neurocompression technology across the European Union. Their patent counsel began the process of preparing European patent filings. This is when they found the problem. The European Patent Office's prior art search returned a result they had not been expecting. A PCT application filed 3 years earlier with a priority date that predated the domestic filing date they had been using as their European priority claim. The PCT application named me as inventor. It named Crestline Research as applicant. The claims were broad, carefully drafted, and covered the exact territory that Hargrove's European licensing deal depended on. Hargrove's outside counsel called Josephine. Josephine called me. "They want to know if Crestline will negotiate," Josephine said. "What are they offering?" "They haven't offered anything yet. They're in the information-gathering phase." "Let them gather," I said. I want to describe what that conversation felt like, because the outside of it looked very calm. I was sitting at my desk in the Aldercroft building. It was early evening. Gideon was working in the next room, and I could hear the faint click of a keyboard and the particular hum of his monitor. The harbor was outside the window, doing its usual slow business. Nothing about the moment was dramatic. On the inside, something settled. Not satisfaction exactly. The word that came closest was confirmation. The thing I had believed was true about the PCT filing date, about the scope of the assignment, about the gap that Hargrove's lawyers had left in the language, all of it was confirmed by the fact that they were now calling to negotiate. If they had owned the international rights, they would not have been calling. They would have been filing. 3 weeks later, they came back with an offer. It was structured as a licensing offer. Crestline would grant Hargrove a license to use the PCT-derived international rights in exchange for a royalty. The royalty they proposed was 4% of European licensing revenue, capped at $20 million total. I said no. "Josephine," I said. "Tell them the minimum terms we'd consider are a 20% royalty, uncapped, on all international licensing revenue. Alternatively, we'd accept a buyout of the international rights at a figure reflecting the full commercial value of the technology in those markets." Josephine relayed this. Hargrove's counsel responded that the terms were unreasonable. I told Josephine to respond that the terms were the terms. The negotiation period lasted 8 months. Hargrove's board grew increasingly nervous. The German deal was on hold. The German partner had done their own due diligence on the IP stack and found the Crestline PCT application, and they were not willing to close a €70 million deal on technology with a contested ownership structure. Similar issues had appeared in the Japan and South Korea national phase entries. The Chinese filing was in a different procedural stage, but the pattern was becoming clear. Every international commercialization path Hargrove tried to build was blocked by a prior-dated application owned by a company they had never heard of until 3 months after I had resigned. There was a legal argument Hargrove's counsel kept making, that the PCT application was covered by the assignment I had signed, that the language should be construed broadly enough to include international filings. This argument had some merit in theory. In practice, it failed on 2 grounds. First, the assignment agreement did not use the phrase derivative applications and did not reference international filings in any explicit way. It was a domestic assignment. Hargrove's own counsel had drafted it. If they had meant to capture international rights, they had the opportunity and the expertise to say so. Second, the priority date. Even if one accepted that the assignment covered the PCT's subject matter, the PCT had been filed and the priority date established before the assignment was executed. You cannot assign something you haven't yet agreed to assign. The timeline, which Josephine had documented with exactness that an independent auditor later described as unusually thorough, showed that Crestline's PCT filing predated the assignment agreement by 11 days. Those 11 days were, commercially speaking, worth approximately $200 million. Hargrove's board moved to litigation. They filed suit in federal court, seeking a declaration that the PCT application was covered by my employment assignment agreement, and an order requiring Crestline Research to reassign the international rights to Hargrove. Leandro took the case. He filed Crestline's response 3 weeks later. The response was 40 pages long. It was, by the description of a neutral patent law professor later retained as an expert witness, one of the more elegant applications of PCT procedural rules and invention assignment doctrine in recent federal litigation. The case lasted 14 months. I want to be honest about those 14 months because I have a tendency, the same tendency that led me to file the PCT rather than fight the domestic dispute, to compress the hard parts into strategy and skip over the experience of living inside the strategy. The experience was this. I went to work every day in a building where no one who passed me in the hallway knew that the outcome of a federal lawsuit was going to determine whether the company I had spent 3 years building would survive. I had staff meetings, I reviewed technical documents, I had difficult conversations about patent prosecution timelines in South Korea. I ate lunch at my desk because I was usually in the middle of something. I went home to an apartment I had furnished slowly, and with the particular frugality of someone who is not certain of the next 12 months. I did not tell most people what was happening, not because I was ashamed, but because the psychological cost of retelling it was real, and I needed my cognitive bandwidth for the work. Gideon knew. Josephine knew. Leandro knew. My father called every 2 weeks, and I gave him a case update in the same cadence I used to give him school reports, and he listened with the same focused silence he had brought to those reports. And at the end, he said things that were not comforting in the generic sense, but were always precise and true. The district court issued its ruling on a Tuesday in early spring. The judge found for Crestline on the primary issue. The assignment agreement was a domestic assignment, the PCT application was an international filing, and the language of the agreement could not be stretched to cover what it had not explicitly addressed. The 11-day priority gap was determinative. The PCT filing date preceded the assignment date, and no retroactive claim by Hargrove could alter that sequence. Hargrove appealed. Of course they appealed. The appeal was heard 6 months later. The appellate panel affirmed the district court. The panel's opinion included a passage that Leandro sent me the evening it was released. An assignee who seeks to secure rights to international patent applications must draft the assignment with sufficient specificity to capture those rights. An ambiguous or incomplete assignment document will be construed against the assignee. Construed against the assignee? Against Hargrove. Against every assumption they had made about what they owned when they handed me that document and watched me sign it. I read the opinion at my desk, in the quiet of an evening after the office had emptied. The harbor was dark. Gideon had gone home 2 hours earlier. I had a glass of water and the text of the appellate decision on my screen, and the particular stillness that comes after a thing has finally been resolved. It did not feel like triumph. That was not the word. It felt more like the moment when a mathematical proof closes, when the last line follows from the line before it, and the logic is complete. There is a satisfaction in that, but it is a clean satisfaction, not a loud one. During the appeal period, Hargrove's financial position had deteriorated significantly. The German deal had collapsed entirely. The Japanese partner had entered into an alternative licensing arrangement with Crestline directly. A clean, uncontested license, because the Japanese national phase entry was ours, and the priority date was ours, and there was nothing Hargrove could do about it. The South Korean entry was an active prosecution. The Chinese filing was proceeding. The domestic licensing revenue, while real, was insufficient to support the valuation at which the Series C had invested. And without international revenue, there was no credible path to the returns the investors had been promised. A board member resigned. Then 2 more. The CEO retired early, which is the phrase companies use when the CEO is asked to leave. Dorian became CEO. I read about this in the trade press, with the kind of attention I gave weather reports about cities I no longer lived in. He gave a statement about refocusing on the core domestic market and building from a position of strength. The statement was accompanied by a headshot in which he looked exactly the way I remembered him looking in meetings. Measured, slightly deliberate, very much in control of his posture. He was not in control of the IP position. Hargrove's board made one final approach after the appellate decision. A proper acquisition offer this time, not a licensing proposal. They wanted to buy Crestline Research outright. The offer valued the company at $62 million. Leandro, Josephine, and I sat with the offer for 4 days. "It's real money," Leandro said. "It is," I said. "They're desperate," Josephine said, which was not a recommendation for or against. It was an observation. I declined the offer. I did not decline it dramatically or with particular satisfaction. I declined it because the number did not reflect the actual value of what we held, and because there were 2 institutional investors who had approached Crestline independently in the previous 6 months. And because accepting $62 million from the people who had taken my invention felt like a particular kind of ending that I did not want this story to have. Hargrove's board received the rejection. They advised the remaining investors that the international commercialization strategy was no longer viable without resolving the IP conflict. The institutional investors conducted their own analysis. The analysis concluded what any competent IP attorney could have told them from the beginning. The Crestline PCT application was valid, the priority date was established, and without access to those rights, Hargrove's global ambitions were structurally blocked. 3 investors withdrew, then 4 more. A restructuring firm was retained. The restructuring firm determined that the company's domestic licensing revenue was insufficient to support the valuation at which the Series C had invested. The Chapter 7 filing happened on a Thursday morning in late October. I know this because I was at my desk when Gideon called. In the 14 months between the appellate decision and the bankruptcy filing, Crestline Research had closed licensing deals with 3 companies in Germany, Japan, and South Korea. We had hired 12 people. We had filed a second patent application, a continuation of the PCT, covering the second-generation compression method that Gideon and I had developed in those first 2 years. We had signed a clinical partnership with a research hospital for an application in non-invasive neurological monitoring. The company I had built was real. It had employees and contracts and a product roadmap and a coffee machine that Gideon had opinions about. On the afternoon of the day Gideon called, I had a meeting with a Series A lead investor who was considering a term sheet. She was a woman in her late 40s who had made a career of evaluating technologies in markets where most investors had not yet understood what they were looking at. She had read every filing: the appellate decision, the German licensing agreement, the clinical partnership documents. She had done the kind of due diligence that takes several weeks and involves calling people who know you. She came into the meeting with a printout of the PCT priority date and the assignment agreement side by side on the table. "Walk me through this," she said. I walked her through it. She listened with the focused attention of someone who is forming an opinion but has not yet committed to it. "You filed the PCT before you signed the assignment," she said when I was done. "Yes." "And you knew, when you signed, that the assignment didn't cover it." "I knew the assignment as written did not explicitly cover it," I said. "Yes." She looked at me for a moment. "Most people would have fought," she said. "Right then. Sued them immediately." "Most people would have lost," I said. "Or spent everything winning." "So you let them have the domestic rights." "I let them have what they drafted the assignment to cover," I said. She nodded slowly. "And built from the international position?" "Yes." She looked at the documents again, her finger resting on the PCT filing date. "The 11 days," she said. "Yes," I said. "What's the second-generation method worth in the Japanese market, conservatively?" "Leandro has a range in the materials." "I've seen the range. I'm asking what you think." I told her what I thought. She closed the documents and put them in her bag. "I'll have a term sheet to you by end of week," she said. She did. I signed it. Josephine called me that evening to confirm she had received the countersigned version. "Your father would have had thoughts," she said. "He has had thoughts," I said. "He called this morning." "What did he say?" "He said the claim drafting on the PCT was clean. He said Leandro was good. Then he said he was proud of me, which he said in a way that meant he was proud of me for about 14 different reasons that he wasn't going to enumerate." Josephine made a sound that was almost a laugh. "That sounds right," she said. After I hung up, I sat for a while in the office with the harbor view. It was evening by then. The sky past the water going the particular layered orange and gray of coastal autumn. Gideon was still at his desk, working on something with the focused contentment of an engineer who has a problem to solve and the tools to solve it. He didn't look up. On my desk was the term sheet, countersigned. Beside it was a printed copy of the PCT filing receipt from WIPO, 3 years old now, with a priority date and an applicant name, Crestline Research. Below the applicant name, the inventor name, mine. I had held on to the receipt not as a trophy. It was a working document, part of the legal record, but also as a document that answered a question I had sometimes asked myself in the hard months: whether the quiet move had been worth making, whether the silence about the gap in their drafting had been the right silence, whether building a company on an 11-day window was a foundation or a gamble. It was a foundation. I had known it was a foundation before I filed. The ship I had watched that morning was gone. The harbor was dark and ordinary. There was one more thing I needed to understand about that period. Not for the story, but for myself. The understanding came slowly, the way most honest understanding does, in pieces rather than all at once. The thing I had done was not passive. That was the word people would use later, that I had waited, that I had let them proceed, that the move was a quiet one. And it was quiet. But quiet is not the same as passive. Every day during those 14 months when I was running Crestline, filing national phase entries, building the second-generation method, prosecuting the PCT claims through examination, every single day I was making a choice to trust the foundation I had built on that Tuesday afternoon when I filed the PCT application. That is not waiting. That is working. The distinction matters because the narrative I see most often about women in these situations, in intellectual property disputes, in corporate theft cases, in the endless smaller versions of this story that happen in labs and offices and boardrooms every week, the narrative is about endurance, about surviving until something external changes, about waiting for the system to correct itself. That was not my experience. My experience was that the system does not correct itself. The system responds to pressure applied at the right point. The pressure I applied was a prior filing date in 106 countries. The right point was the moment Hargrove tried to go international. I had chosen that point carefully. I had built toward it. The foundation was a form, a fee, a Tuesday afternoon, and 20 years of knowing exactly how the system worked. The harbor was dark and ordinary. I put the term sheet in the file. I turned off the desk lamp, picked up my bag, and walked out into the hallway. The elevator was waiting. The doors closed. The building hummed.